Up next, the Cannabis Reporter Radio Show with Snowden Bishop. After this message.
Most people don't realize that cannabis is serious business that requires serious technology solutions. Hi, I'm Terry from Sunstate Technology Group, where we are seriously proud to provide technology and security systems that help cannabis companies compete and succeed. From planning and expansion to hardware and daily IT support, I'm here to tell you that having the right technology is critical to security and smooth business operations. Partner with a technology team that understands the unique needs of this industry. For details, visit sunstatetech.com/cannabis. sunstatetech.com/cannabis.
And now, it's time for the Cannabis Reporter Radio Show with Snowden Bishop. Listen in as Snowden interviews cannabis industry pioneers, marijuana experts, policymakers, medical practitioners, patients, and other amazing individuals with compelling stories to share. It all happens right now. Here's the Cannabis Reporter, Snowden Bishop.
Evergreen is calling.
Hi, and welcome back to the Cannabis Reporter Radio Show. I'm Snowden Bishop, and I'm happy you could join us. When Congress passed the 21st Amendment to repeal federal prohibition of alcohol, a number of states opted to maintain statewide temperance laws until 1966. Mississippi was the last dry state to finally end prohibition, and even then, states had the authority to enact their own rules. For example, they could limit the sale of alcohol on Sundays or after 2 a.m. every other day, and some limited the age to legally purchase alcohol to 18 years of age, others 21 years of age. Some states have allowed counties and municipalities to set their own local laws, and to this day there are dozens of dry counties where you'd be hard-pressed to find any alcohol at all. Ending the prohibition of alcohol actually required ratification by 36 states, which means 3/4 of the states had to agree to it in order for it to become a constitutional amendment. Today, we have 33 states, plus Washington, D.C., that have legalized cannabis for medical or adult use. So it's getting really close to the point in our history when we might see an end of prohibition in the very near future. And when that happens, we'll likely see a similar scenario play out, with states adopting their own rules and local municipalities adopting ordinances within their own jurisdictions. As more and more states adopt cannabis legalization measures, industry stakeholders and consumers alike are grappling with the fact that not every municipality is on board. Some state measures allow local governments to establish their own ordinances having to do with zoning, permits, licenses, and hours of operation, while some states require municipalities to get voter approval for local ordinances that stray too far from state rules. Others are just simply at the mercy of local city council or county commissioners. But either way, discrepancies in the law wind up being settled in court. Such was the case in Charlton, Massachusetts, where the local land court ruled in favor of an agricultural landowner who had been barred by the local town council from converting his farm into a 1,000,000-square-foot cultivation facility. In a state that's still in the process of closing legislative loopholes in its adult use measure, and where local lawmakers have yet to learn the many ways in which cannabis can help make a positive impact in their communities, the land court decision was actually a big win for the industry. That's the topic of today's show, and our guest is here to help us understand just how that decision will impact Massachusetts and other states that are in the process of legalizing cannabis. Robert Munelli is an attorney with the Boston law firm Davis Malm. He specializes in regulatory law pertaining to communications, technology, and cannabis. As co-chairman of his firm's cannabis practice group, he's been actively involved in helping to solve some of the industry's regulatory challenges and shaping the state's pending legislative measures having to do with the adult use policy revisions. Rob, thank you so much for joining me today. I am so happy you could be here to join me for this. I was really intrigued by this land court case, and I know that you're exactly the person that I need to talk to about it, so I appreciate it. Thank you.
Oh, happy to be part of this. Thanks, Snowden.
Oh, you're certainly welcome. So before we get started, why don't I hear in your voice your area of practice? Because I know you do have a specialty in cannabis. Am I right about that?
Yes. I'm a partner at the Boston law firm of Davis Mom, and our firm really has been involved in cannabis-related activities since the medical phase of Massachusetts started nearly a decade ago. And then as it jumped towards adult use legalization, which happened in a 2016 ballot initiative, and then follow-up statutory development, we got involved. We built a practice group of people with different expertises. We have people who do land use, tax, business, investment type, and corporate structure issues. And I focus in on the regulatory side for the most part. And I'm one of the co-chairs of the firm's cannabis practice group, working with the State Cannabis Control Commission, getting people licensed. It's a very elaborate licensing process in Massachusetts, so I've been the one who helps manage the process of getting people into the Cannabis Control Commission licensing process and helping them through it.
Right. And it's been a year since the adult use law was passed. How's it going?
It depends on whose perspective you're talking about. From this perspective of, it's been I would say a mixed bag. I think the state regulators are trying hard, but they really adopted a difficult licensing scheme. They modeled it in spirit on the kind of the gambling industry. They want to make sure that people who are in this industry know exactly what they're doing, that they have policies developed before they jump in with both feet, that there's as many assurances as they can get that people will not divert product to people under the age of 21, that they will maintain product quality, all that type of stuff. So it's a pretty elaborate process. The early winners really are the existing medical licensees. They got a jump start through the licensing process. And so many of those are already in business and making sales. It's been a longer haul for the independent startups who want to get either a retail shop going or a cultivation operation of various sizes or an edibles manufacturing entity group up. So the first retail stores got licensed in, I think, November of last year, right around Thanksgiving time, and then they've been progressively increasing in the number of ones that are getting the final operating licenses, allowing them to sell. So I think we're now up to 20 retail stores. I think there's probably 13 or 14 cultivators that are growing for adult use. There's 13 or 14 edibles manufacturers in place. So it started very slow, but now it's up to 30 or 40 million bucks a month in gross sales. And so people are starting to get happy that it's starting to fulfill the promise to the industry that people had hoped to see.
And when it comes to the licensing, how difficult is it there for people to qualify for a license?
It's not theoretically, but it's just getting the whole package together. It takes time and effort. It's certainly any large provider is going to put resources into getting it all right and getting it thorough and being able to pass muster. It's a little bit more of a challenge for the smaller providers, but they're doing it.
And is there a limit as to how many licenses are issued?
There's no license number limits at the state level. It's just that it has a multiple set of licenses to apply for. You need one license that's kind of like the application that says who you are and who your principals are and what your financial commitment is going to be. They will then vet. And then everyone involved in the group has to pass a background check. And then you have another application that's all your policies. And typically, depending on license type, it's somewhere between 15 to 20 policies you have to have in hand that are detailed summaries of what to do. And then you just have there's a separate one to pay, various fees. If you qualify and meet the standards, which is essentially you show that you can substantially comply with the 75 pages of regulations that are in place, you'll get a license.
Well, that's good because there are some states that have like a limitation on how many licenses. And so it's hugely competitive in those states to just try to secure a license. And it can be quite expensive too. but it's good to know that they don't really have a limit.
So the issue is not the limit at the state level. It's the issue of limits at the local level where it can get potentially challenging for a particular operator.
Right. And that kind of leads me to this question about the land use court. And I know some municipalities around the country are really fighting having cannabis businesses within their city limits. So tell me just an overview of what happened with that, because I know it was a huge win for the industry.
Mm-hmm. No, that's fine. I'd like to step back a little bit on that to put the decision in context, which is, as I noted earlier, there was a state ballot initiative that was designed to figure out if there was public support for legalization of adult use, and it passed. And then the legislature went ahead and codified a law that filled in some of the details, modified some of the terms of the ballot initiative, and was ready to charge forward. And one of the issues of that was, what is the ability of municipalities to say no to adult use? And under the state's medical licensing scheme, they could not say no. They could only potentially have zoning limitations of having a marijuana district. At the adult use level, they decided to come up with a different scheme for that. They said that towns could say yes or say no to cannabis, but they had to do it in particular ways. The big one being that if you were a town who said no to cannabis at the ballot initiative level, in other words, you didn't have a majority of supporters in your town, then the city council or the town board of selectmen or the town meeting or whatever the government form could have a vote to say no to cannabis, and that's it for adult use cannabis in your town. If you were a town we had a majority yes vote for cannabis, it isn't that easy. You'd have to go ahead and have an actual popular vote somehow, not very well defined, but they had to be able to have you had to put it to the town voters, and the town voters would have to I guess, approve the decision not to have cannabis in the town. That's the way they teed it up. So if you're a majority no town, then the town could handle it in its own way. If you're a majority yes town, then the town couldn't just do that. They had to put it to the voters. And then the question for the case you were talking about, which was the town of Charlton, is what is the standard for approving a no vote to cannabis? And in that case, the question really came down to, is it something that you could, would you have to do it through the bylaw process, which is a municipal vehicle for regulating built activities in the town? And the thing is that the general principle of bylaw law is that you need a 2/3 vote to do anything. So the question is whether they would have to vote to prohibit cannabis by a 2/3 town vote, or would it be a simple majority that you could do under a general bylaw? And so that really teed up the case. In that case, it was a town that had actually did put an adult use ordinance in place and went down the bylaw road, and they passed that general ordinance by the 2/3 vote. And then the question then became, they then had somebody put a general bylaw in place to prohibit cannabis in town, and they passed that. But that was the way that the proposal was going to be, that you would have to, by simple majority you would be able to pass a general bylaw that would prohibit cannabis in the town of Charleston. And that's where a particular operator who had a very large business, medical business in that town, and wanted to get in the adult use business, ended up filing suit in land court to be able to say, no, you can't do it. You have to do it. You can only set up that vote so it's a 2/3 or nothing on that. And that was the state of play with the case. And back in March, the land court did come out with a decision that said, if the town starts going down the bylaw process for cannabis, you have to stick with the bylaw process for trying to ban cannabis. And in that case, it went to the town meeting, and they didn't even get a majority vote in that ultimately, but they at least established the precedent for some towns that if you start with a cannabis bylaw in place, the town can't go ahead and then shift gears and say, we're going to just do a 50% vote to ban, that you had to do the 2/3 vote to ban. and which is obviously a much harder standard than a majority vote.
So in Massachusetts, do the proceeds from sales of adult use go at a state level to education or